of São Paulo for your kind invitation to this very interesting and important event. I will share my presentation now. I hope that you can see it. So Professor Maranhão asked me to give a short introduction to the AI and law topics, and in particular to the activities of our association, which is the International Association for AI and Law. So I focus my presentation to these two main points. So it's definitely well known that the current information society is characterized by keywords like semantic web, linked open data, smart data, ontologies, natural language processing, and in particular about artificial intelligence, which is affecting the most part of our activities and area of interest, starting from the economy, the healthcare system, the public administration, and also in particular the law. And the combination of AI and law is something that comes from afar. Effectively, the law, we can say that is made of rules and interprets and creates facts. And similarly, the Turing machine, so basically the computer, is able to process facts in the form of data using specific rules encoded in different formats. And it does it according to two main paradigms. We can say that, first of all, the symbolic paradigm, in which basically rules are expressed by symbols, and the processing of data and the reasoning of the computer is made of a collection of rules and algorithms. And examples of this kind of paradigm is basically implemented in expert systems. And another paradigm is the so-called subsymbolic paradigm, or the connectionist model, where rules are encoded as a combination of elementary processing structures. And this paradigm is characterized by learning by examples. And an example of this kind of paradigm we can find in neural networks according to different variation that we can find in the literature. Now, we can say that the International Association for Artificial Intelligence and Law was born actually to deal with this kind of interest. So with the aim to support, develop, and promote the field of AI and law in the international level. And the main goal of the association is to organize a biannual international conference of artificial intelligence and law, which this year is basically organized by University of São Paulo. And the first ICAIL conference was organized in 1987 in Boston, and more recently at the National Research Council in Rome, at the University of San Diego, at the King's College in London, the Cyber Justice Laboratory of the University of Montreal in 2019, and this year, as I said, at the University of São Paulo, unfortunately only online due to the pandemic, but with additional challenges and opportunities at the end to have a wider audience. You can find the main information about the association, the official website, and here you can find the address where basically the main information about all the activities are reported. In the last years, we had several presidents of the association, starting from Thor McCarthy in 1992-93, and then Marek Sergot, Edwina Riesland, Anya Oskamp, Kevin Ashley at the University of Pittsburgh. In particular, I would like to underline that Kevin recently has published an interesting book on, which is an interesting introduction to the AI law topics. Trevor Bench Capon, Carl Browning, coming from the industry, so not only academics, Tom Gordon, Henry Praken, Giovanni Sartor, Ralph Winkels, Jack Conrad, also coming from industry, Katie Atkinson, and finally Bart Verhey of the University of Groningen. And in the last 2 years, I have the honor of chairing the executive committee of the association with Floris Bax, Michael Araskiewicz, Daniel Boursier, Monica Palmirani, Juliano Maranhão, and Dave Lewis. So our goal is actually to coordinate the activity of the association, and in particular to organize the main event, which is the ICAIL 2021. As for the topics that let's say the activities that are carried out by all the scholars, let's say the researchers in our environment, we can say that the topics of artificial intelligence and law and the research in this field have been moved by two distinct motivations. One is a practical motivation, and the other is a theoretical one, as Thor McCarthy used to say in an interesting paper of his in 1990. In particular, the theoretical motivation has the objective of gain a better understanding of the process of legal reasoning and legal argumentation using computational models and techniques. On the other hand, the practical motivation aims to build intelligent legal information system supporting legal practitioners and decision makers and citizens. Let's have a look at some scenarios that let's say focus the attention on the interest topics which basically our community is dealing with. The first scenario is the one that I have called the information retrieval scenario. Let's consider a user that who wants to subscribe an online contract. He might be willing to know more about the consumer protection law, and in particular, he might be interested in consumers' rights, for example, the right of withdrawal, or the supplier's duties towards the consumers, which are basically implicit rights of the consumer himself, or the procedure to fulfill the consumer's duties and the sanction in case of not compliance. Now, nowadays, there are no search engine or retrieval system or processing systems able to respond to this interest. So what we need is a legal information retrieval system endowed with reasoning facilities. And the scenario is made more complex, for example, considering the multilingual environment, for example, which we have in the European Union, but also if you consider a sort of federative approach in processing legal information over the internet, what you need is a unique point of access to resources in a distributed environment. So having an advanced legal information and retrieval system endowed with reasoning services, able to respond to queries, complex queries like which version of the directive 2003/98 EC adopted in November 2003 was in force in June 2013, or another complex query, in the country X, which law is applicable to divorce of cross-border couples, or which national laws on consumer protection do apply in a specific region, or let's say going in more semantic-oriented interest, which are the rights of the consumer according to the EU law, or which are the implicit rights of the consumer according to the EU law. As we said before, these are complex inquiries that cannot be solved, cannot be addressed in an effective way by the current system, in particular search engine system, even advanced, because what you need is actually retrieval and reasoning, advanced retrieval and reasoning services dealing with legal information. Another scenario, the one that I called the legal compliance scenario. Let's consider you want to detect, I have a system which is able to automatically detect the speed limits according to speed limits regulation. You might be interested in checking drivers' compliance with regulation about traffic speed, or checking such compliance in presence of conflicting rules or rules changing over time, what it is usually addressed in literature as norm defeasibility. Also in this case, you need systems able to implement compliance checking of rules, of legal rules endowed with reasoning facilities. Another scenario, the third scenario, which I called a legal dispute scenario. Usually a trial can be conducted in a traditional way based on rules, precedents, and the dialogues between and among parties. But in the current information scenario, information system, information environment, the users might be willing to go with alternative dispute resolution services supported by digital tools. And in this scenario, what is important is to have the possibility to transform the general theory of argumentation in a way which is amenable for computation, like let's say having, let's say, models for dialogues between parties, or models able to analyze rules and precedents in an effective way. That's why in this scenario, we used to address the problem in terms of applying computational argumentation in law. And this is one of the main topics that is addressed by the literature in the field of AI and law. These are the topics of ICAIL 2021, which basically detailed more the scenario which I have talked before. For example, argument mining for legal text, or automatic extraction of information from legal databases or legal text like legislation or case law or administrative acts, or let's say ethical aspect of AI and law, or let's say modeling norms, or modeling legal knowledge and legal knowledge representation, and finally open and linked data in the legal domain. In particular, one of the most important environment of interest for the AI and law community is actually the semantic web, also called in literature like Web 3.0, Web of Data, or Internet of Things, which are basically more or less synonyms. The semantic web is important because it's actually an evolution of the internet has and that the web has we have as we have considered so far, where the information is understandable not only by humans but processable and understandable also by machines, in order to have as objective the technological, semantic, and multilingual interoperability between information systems, and having the possibility to develop advanced access service. So basically, it's let's say you can understand how this scenario can be of interest for implemented advanced services, also for the legal domain and for providing legal information systems over the web. And in particular, in the last few years, a great promotion to the semantic web has been given by the so-called linked data movement, which are structured and correlated data on the web, or the also called linked open data movement, where we address linked data in terms of data published on the web with open licenses. So basically, the semantic web is made of linked open data. The semantic web is the whole, while the linked open data is the part. And an important boost has been given by the so-called five-star rating schemes for linked open data, coming from a very famous article written by Tim Berners-Lee, who is the creator of the web, providing basically a ranking related to the quality of data at higher degree of complexity, which can be published over the web. Why it's important, the semantic web in the legal domain? Because the combination of the semantic web standards and the linked open data, so the availability of data, processable data by machine, allows you to have the possibility to transform the law as a code. So having legal information processable not only by humans, but also by a machine for creating advanced legal information systems. And about these very topics, in the next talk, Monica Palmirani of the University of Bologna will be addressing this aspect about legal markup languages, LegalRuleML, and challenges of computable law. Similarly, Adam Weiner will address another scenario that we have discussed before, so providing an introduction to argumentation systems. And finally, Burkhard Schafer of the University of Edinburgh will talk about ethics and the law of AI, which is a very important topic, considering also the recent interest of the European Commission in the ethic aspect of AI has applied to several domains, including the domain of the law. So enjoy the next talk, and thank you very much for your attention.
Thank you very much, Enrico, for your talk. Before we proceed, I would like to emphasize and thank our sponsors for this event and the ICAIL event. We have as sponsors the Use Brazil, which is a search engine for legal documents and jurisprudence. Urbano Vitalino Advogados, Legal Code, is a law tech, and LegalRuleML, which is the Institute of Research on AI and Law. So thank you very much for our sponsors, and I will move forward now with a question to you, Enrico. I would like to know, within these scenarios that you have displayed, what do you see currently and nowadays as the biggest desideratum, if there is not only one or two or three biggest desideratum and challenges, which are the breakthroughs that we are searching in the research on AI and law nowadays?
Yeah, actually, in the legal domain, we are facing problems which are more or less similar to the challenges that we had in the early past in the internet. For example, implementing services, search and retrieval services for legal information is one of the main challenges, and is still one of the main challenges. Given the user the possibility to retrieve legal information in an effective way and improving precision and recall, and having the possibility to search not only documents, but in particular norms, so legal provisions, basically. And having the possibility to implement reasoning services that allows you to detect, let's say, advanced or technical or more precise information about legal matters. This, I think, it's an important step because, let's say, search engines are the most famous services over the internet, and still users, like, for example, legal practitioners, are looking for services like the one I mentioned. But not only this type of services, everything that can be conceived when you have the possibility to transform the law into code can be considered of interest for not only for let's say legal practitioners, but also for example, policymakers. You have let's say the possibility to implement advanced services for the final users. So legal, artificial legal advisors, for example, the possibility to go with alternative dispute resolution services. And everything is possible if you have the possibility to transform the law into a machine readable format, and in a format which is amenable for computation. So I think that basically this is one of the main area of interest. That's why I think, for example, that the actual implementation of the semantic web theories and practice in the law is still probably one, and probably the main challenge in our discipline. On the other hand, just two words also about the problem of legal argumentation, which is another very important aspect, which comes mainly from the so-called theoretical motivation. It's also a very interesting part, because it is able to address the two different modality to deal with legal stuff. So the let's say the common law or civil law approach to the resolution of disputes, and in this respect, having the possibility to implement automatic agents able to deal with this scenario, these approaches, it's an important step, which basically allows you to study the let's say the theoretical part of argumentation and to implement it in a concrete cases.
Sorry, thank you, Enrico. There is another question here. You have talked about symbolic and sub-symbolic methodologies, and the question is about the landscape of the research community nowadays, whether there are the research spends more energy on knowledge representation systems or on machine learning systems or data systems, and at ICAIL, what is the landscape nowadays?
I would say that it's a combination of the two approaches. You can say that there is a sort of a top-down approach, mainly devoted to the representation of legal knowledge in terms of ontologies, for example, legal knowledge models, and the bottom-up approach, more oriented to extract knowledge from legal text and to map this information to knowledge models. Let's say they are, I would say, complementary. And in our community, let's say we have more or less the same interest to both of the approaches. Just because they are actually the same, the two faces of the same reality. From the one hand, if you are more interested in information retrieval, probably you are more interested in a bottom-up approach, because you want to extract knowledge, you want to detect specific keywords, having a classification of legal materials from the bottom. On the other hand, if you are more interested in the implementation, in the automatic implementation of a legal reasoning framework, I don't know, like for example, Opheldian reasoning or legal compliance or reasoning, and so on, you are more interested in implementing knowledge models using ontologies or other similar schema. But nowadays, the implementation of ontologies, since it addresses the effective implementation, the actual implementation of the semantic web, it's of particular interest by researchers.
Perfect, Enrico. Thank you very much, and congratulations for your talk and the discussion. It was very insightful.